Good morning.
Good morning.
I think they're discussing, okay, who does the introduction. And those of you who I've met before, Professor Shepard, Professor McMurtry, Chubb, you all know I'm regular folks, so I can introduce myself. My name is Verda Colvin. I'm the newest Superior Court judge here in Macon, Bibb County, and I do that. I've never seen consolidated governments not put both names together, but we have yet to do that, but I'm doing that myself. So I'm the newest Superior Court judge here. I was appointed by Governor Nathan Deal April 17th or 16th, and I think I started the next day, the 17th. And so I've been on the bench for a while. It feels like I've been on the bench now for 5 years, but it's only been since April. And originally when I was asked to do this, Professor Shepard asked me after she had come to one of her classes, and she talked to me a little bit about what I was supposed to do, but I was like, it was so amorphous, I thought, wow, you know, because that's the academic world. And then I saw Professor McMurtry Chubb at another seminar I went to regarding Appleseed, and I asked her, I said, okay, I understand from Professor Shepard what I'm supposed to do, but give me a little bit more meat to this, because I don't see how this can last an hour. So you want me to be lucky that you have a shorter time with me than what it's scheduled. But from talking to both of them, what I gather I'm supposed to talk about is maybe things that law school can do to bring the practical application of the law to students. And so I'm not the youngest person on our bench, believe it or not, is Judge Self, even though I'm the newest judge. And so I thought, well, maybe he would have been better for this, but I was asked, so I'm doing it. So I had to go back in the traces of my mind to remember when I came out of law school, what did I feel like I didn't have and what I see now. So the first thing I wanted to say is, when and it's kind of good that you asked me to do this, Professor Shepard, coming on the heels of being a new judge and seeing some things for the first time in a vantage point that I had seen. I will tell you, before I took the bench, I was a federal prosecutor here in Macon at the U.S. Attorney's Office, and I had been doing that close to almost 15 years when I was nominated for the Superior Court bench. And so I tried cases there. Before coming there, I was at Clayton County DA's office in Metro Atlanta. I was there for 3 years and, you know, did everything we had ever done and did some more things there. I had been in private practice when I first started out, so that's where I tried to go back when I thought, what did I not have as a student? And in private practice, I was lucky enough to be with a firm that was still small enough. It was a boutique firm that we did everything, and they primarily, their claim to fame was civil rights, but like every firm, they did medical malpractice, all the things that made you money, but they kept that title so they could be boutique. I'm so glad I can say that now. Outside of that, I worked as an assistant general counsel at a university. What else have I done? I've kind of done the whole gamut: corporate, private firm, government work, and so I think I do come with maybe a different perspective. What I found when I got out of law school, one of the first things I wanted to say, I didn't get enough practical application. I think students need even more than, you know, I'm so amazed at what law students get now, and I think Mercer does an outstanding job. And, you know, I graduated from Georgia, so don't hold that against me from law school. But, you know, and I don't go back and visit as much, but I just hope they're doing the kind of things you all are doing here as far as practical application, because I don't remember having all of that when I was in law school, and I'm 49, so I'm sure things have advanced since I was in school. But one of the things, I talked with my staff attorney, Gracie Paulson, who just graduated last year, about give me some ideas, and so she helped me remember some things. One of the things I want, this is a big thing, and I think it will help law schools increase their numbers, because I understand the numbers are going down. I understand kids get a little disenchanted about the idea of law school, and to be quite honest with you, I have heart-to-heart conversations with friends of mine who kids want to go, to make sure they're going for the right reasons, and not just because of what status they think you get with it. I think one of the best things you all can do for students is to have a practical application, and I came up with this name, Law to Life. And what this class would encompass is a law degree. What can I do? And give them a broader perspective of what a law degree means and what can be done with it. Because I think most students, when they enter law school, think corporate, trial, making a lot of money, and making a big name for yourself. And it's so much deeper than that. And I think academics like you know that. People like me who have a servant heart realize that. But if you don't fall in one of those categories, what do you know? And let's be honest, how many law students do you all have that really fall in one of those two categories? They love the law, they want to do it for the academic part of it, or they want to be a public servant. And so if they don't fall in that, we've got to give them something to justify the expense and the time. So if we start showing them other ways in which they can use a law degree, like one of my friends, she worked for the big firms in Atlanta, the ones where you make like $250,000 or $300,000 a year. Oh, she's never been married, no kids, so she just got money coming out of her ear. Well, since she made so much money, she just thought, I'll do some different things. She's now like a private attorney for this multi-billionaire someplace, and she flies to different places to check on his different business entities. Some of that's legal, some of it's just negotiating, but it's out the box. And she's decided, I know I can do that. I've made some money. Let me do some different things. She was legal counsel for Atlanta public school system. When I was in law school, nobody told me that was a possibility. I never thought about counsel for, public school entities. And imagine what they could do. I think about it. If they got it, and in Atlanta public school system, they have a staff of attorneys. So like she was in charge, one of my other friends who used to be a city attorney here, he went to work for her when she became the head attorney for the Atlanta city school system. And he said, oh yeah, we've got about 5 of us who work with the school system. And I thought, kids don't know that when they're getting out of school. And that would be an entity that would be welcome to employ somebody fresh out of school, at least for 1 or 2 slots, because they can cut down the expense of the legal team. I never would have thought of being assistant general counsel for Clark Atlanta University. I'll tell you how that came about. I was pregnant, I was working in Baptist, but my husband and I lived in Lithonia, Georgia. That's about an hour, 15 minutes away. I was commuting every day. And I commuted up until I had that child. And I was a travel attorney. It was when I was in the solicitor's office there. And in the solicitor's office, I don't know about here, but there, sometimes we were literally at work at 9 or 10 o'clock at night, because if we had a long calendar, we had to stay till we got it done. And I was like, I can't do this with the child. I had started checking in the daycare there for when I went back to work, but I was like, I can't be traveling at night like this with him. So I started looking, just doing what we do and looking for jobs, and it came up, and I'm like, I don't know if I qualify for this, but let's see. And so I went and interviewed, and I didn't tell him I was expecting. So when I showed up, I was like 9 months pregnant. So, it's a guy who's doing all, since he's in the private industry, he knows you can't say anything about the fashion. So he looks in the air like, oh my God. And he told me later on after he hired me, I was ready to make you an offer that day, but when I saw you, I thought, I can't hire her because I need somebody to start. And he did everything men think. We want to be moms to the extent we're going to want 5 months off when we have the baby. We're then going to want to be off anytime the baby sneezes. And he had all those ideas. He said, and I kept interviewing people, but I couldn't find anybody who I wanted over you. So I took a chance. So I want you to, so he's telling me, I'm thinking, you're still violating laws by telling me. So we're going for that. But I never even thought about being assistant general counsel at the university. And had he not been such a not nice person, that's another part I'm going to get to that I think law schools need to help more with. Had he not been so hard to work for, I thought, this is great. I can stay here. My children can go to school for free. Then I can pay for them to go to any graduate school they want to go to if they didn't want to go to a Clark Atlanta, but get your undergrad for free. Go wherever you want to go. I'll pay for that. So I had this grandiose idea, and I had just had a child. But I thought, good, his college education is paid for. But nobody, of course I didn't stay there. That's obvious, so no college education, but that's paid for. But nobody ever told me that was a possibility. And I don't know if I would have pursued that because I really wanted to save the world and I wanted to be a trial attorney. But if I didn't, that would have been an idea. And so maybe if we had a class, or you all could incorporate it in some other class about practical applications, and the best thing brings people in from these novel concept ideas, because you don't have to even really practice law to use the law degree. And students don't think about that, like writers for books. You can put yourself out there to help them with all of the legalese that come with publishing, and not really practice law, but do it from the comfort of your home. and get several writers, and you get one good writer, then he tells other writers, or he or she tell other writers, you get, and this is just off the top of my head, but all the ideas, and I think we have done ourselves a disservice not to share that with students. And I'm sure you all probably have done it in individual ways, but imagine if, and you know, I'm giving you all this, imagine if you were the first collective group to do that in a university setting, and you kind of, that's kind of like, you know, you start letting your students know that, and that increases your numbers before the other schools fill it, because they're getting some options. And then you can see those as internships too. Invite them to come on campus to interview those different areas. So that's the thought I had, because just thinking about when I got out of law school, I thought, you know, there needed to be, if there can be, a real life class on pleadings. One thing Ms. Paulson said, Judge, once I got here, I realized I wouldn't know how to do a deposition. What do you do first? What do you do second? Interrogatories, how do you figure out which ones you ask, because they're limited, you know, and I didn't, you know, and I thought, you're right, I didn't know that either. Like, and how do you do that? I don't know, but this is just a template. You can maybe add it in with some of the class where it fits. Maybe with trial practice. Maybe you do a civil problem that first semester and you actually do mock depositions. And the attorneys who do a lot of civil have them come in to show them what you do in depositions. I know what I've seen is that some people just, it's like they just go to deposition and ask questions. Nobody made objections. They come to trial and then they want me to rule on all these objections, and I'm thinking, the rule says you're supposed to make objections during the deposition as if you're at trial to preserve that issue. But then they want to use this catch-all now that says, well, Judge, if it's in violation of the law, what is it, cumulative in violation of the law, you know, that catch-all that gives you 3 that says even if you didn't object, you can now object on that basis. I'm like, that's not why the legislature made that statute. But it's all because they didn't properly preserve them in the deposition. And I'm thinking, this kid, you know, he was one of the newer people at the firm, he probably didn't know that. And now they're using that as an excuse, but really the reality of it is he didn't realize I should be really paying attention and objecting about anything I don't like. Even if you didn't have a basis, just object because you don't like it. And so I thought of that. Let's see. So we thought, how do we say this? Advanced litigation, maybe. Practical law. One thing she's had to deal with, and I'm having to deal with too, because I didn't do a lot of this when I was in private practice, summary judgment motions, and maybe the way you draft those and how they're drafted. And I'll say this before I forget. I have a hearing today, and there was a letter that went out before litigation ever started. The letter was so well drafted to the layperson it was going to. I thought, this is superb. I just thought this is a great example of how you try to avoid litigation, but in anticipation of litigation, you do this letter. When you attach it to your exhibits, it is so powerful to a court. Because now, you know, the thought would be, well, they told you everything to do, and why didn't you do it? And I thought, but this is a very seasoned attorney, and I won't reveal the name, very seasoned attorney, very sharp. And I thought, but how many years did it take to get to that point? So maybe if they, a little thing like teaching how to write persuasive letters to espouse your position to avoid litigation, and it's going to end up helping you in the long run because you're attaching that as an exhibit, and the court sees, wow, we didn't have to be here. And, you know, let's be honest. That means something to a judge when they say, I mean, you know, that factors into everything else. And so, if we do legal research and writing, but I bet we've never thought about that in legal research and writing, other forms of writing that are just as important as the briefs you do before you ever get to that point. So that could be something that's just added in legal research and writing, but it's a practical tool that they'll use when they get out. And particularly those who are here putting out their own shingle. Boy, they need to know that right off the bat. Responses to discovery. I think a lot of, and maybe this is something they just have to get when they're out there doing it, but I see Professor McMurtry Chubb. I always want to make sure two names up.
Professor MC.
Okay, I see Professor MC shaking her head when I said this, but if there's some way we can get them to know some of the basic OCGA codes, like the one that I was talking about regarding the discovery, you know, those time frames, because lawyers, don't know them. I mean, you know, they don't, you know what I'm saying, they haven't used them enough in the, I kind of think of being a judge, it's kind of like what you all do. You know the details. You have to. And so, I am required to know the details. And so, many times, sometimes you wonder if they know the details. And I'm wondering, well, maybe if that would have been emphasized in school, maybe that would be better. My thought on that, prepare before you come. Because I don't know all these details either, but like I tell them before I go to a hearing, I have read everything you've written. And I've looked at least the major case law that you cited. So I've kind of versed on it, but you know, maybe if they worked more with it during law school, it would show, you know, when you deal with the pleadings. And I'm trying to think, what else did I think about? Let me look on my little sheet. So I think that's about it, but I think you get a gist of what I'm saying about just practical application, just the day-to-day things that you need to know when you go out and practice law. And I thought about this when I was in school, and I think they're doing a better job of it now, because having judged one of the trial advocacy classes and looking at the fact patterns, you know, when I was in law school, the fact patterns were never realistic. And we talked about this, Professor MC. Just make fact patterns that are realistic for them to use real application. Oh, and I won't say who, but I got a little bug placed in my ear. Teach students how to use those things that they will use out in the real world. So Blue Book is what we use. So make sure they know Blue Book. And I know it's another one that you all use, I've been told, but Blue Book is what we use, and I understand Law Review uses Blue Book. Oh, it's the same?
It's essentially the same format. It's just a different way of presenting the material.
Okay, so that's my little plug from that.
So Georgia uses Blue Book?
Yeah. Well, when I was in school, that's all we used. I didn't even know anything else existed. So when I was
it's
told
only
that,
been in the last 10 years.
Okay.
But I mean, so Georgia, I'm not from Georgia, so Georgia courts use Blue Book form.
Yes.
I teach it in Ohio, and Ohio court, of course, Ohio has its own citation form.
Really?
Yeah. So it actually there's no.
There's no
I'm
book.
telling students that I'm like, okay, I'm teaching you this, but when you go in practice, you're going to have to find something different.
Oh, okay.
California has its own.
Wow.
Yeah.
Which is
why wouldn't we just be uniform?
Unique, Judge.
The 11th Circuit actually has in its rules Blue Book or all the other.
Oh, do they? Okay. Okay. So that was I forgot I was supposed to say that.
We should make it more realistic, even if we start with one.
Yeah.
Say, okay, you could do an assignment with the local citation.
Yeah.
I could do that. I could do that. Yeah.
So I think that covers kind of the gist of what I wanted to, what I thought I could add or share. Because I think for me, if I think about what made law school hard or different from practical application, I know I told you.
No, I was just looking to see what time it was.
What made it hard for me was that it just, everything seems surreal, not like something I could actually, like something that actually happened or something that I could feel or touch. And so, you know, real life applications, real life, like sometimes I think about legal research and writing, believe it or not, was one of my better grades. But I just thought it was so, the fact pattern sometimes I'm like, really? I'm here. And so I'm sure nowadays, particularly with you, Professor, it's not that way. So,
Can we open up the dialogue?
Yes.
Okay. So, thank you for your remarks and for your suggestions. My question is, what do you do with students who don't want to learn practical application? Because that's something I've been thinking about. It's something that I'm writing about right now. And that I do in my classes. We do motions for summary judgment, we do meetings, we do all of it. And particularly my class last year got a ton of pushback, especially on evaluations, because they were like, Professor MC wants us to be in the real world and we're in law school.
Wow,
so,
that is so
in the real world.
So I'm just wondering, what would be some strategies? Just
Please tell me that can only be 1 or 2 evaluations,
Okay.
right? Okay, now see, that's concerning because that means somewhere along the way, there's been a disconnect. If you can't learn in a way that's practical to life, what is the point of the learning? And it's great to learn just because, but you're paying to learn for, oh my God.
It's enough evaluations that I can write a law review length article about it. So I am just, it is, and I got the complete opposite reaction from my class this year, which is heartening. But, it was kind of virulent almost. Like they were really resistant. And so I'm wondering if you have any.
Do you think there was something else going on with that?
Professor Colvin.
Sometimes I wonder if if negative is really about something else.
I think there were, but some of them have since. These students were so upset with me that they would avoid me in the. They wouldn't. If I got on the elevator, they would get off.
See, that's what I wonder. Was that something else going on? Because that doesn't.
But they subsequently, some of them have come up to me and said, "Oh, when I went out in my summer job or whatever, what you taught was really, really practical for me."
I'm going to tell you something somebody said to me today, and I am who I am, and I have been told don't change, despite feeling like I'm very different than what my title suggests I'm supposed to be. But I will tell you this, keep doing what you're doing, because it's the right thing to do. And even though you're doing good things, that doesn't always mean everybody will appreciate it, but that is who you are, that's what you bring to the table. And my thought is, sometimes people don't know what, in a way, law students are like babies, because people don't know what they need. You have to tell them what they need. You have to give them what they need. And so, they don't really know what they need. So you keep doing that because that's what they need. Because when you get out there, I remember my first year at that firm, they didn't hire many associates. And they were very selective, and it was the most novel firm in the world. I would never trade that experience. They were into this. They did the first bus desegregation case, the Charlotte-Mecklenburg case, and they were so into racial harmony that they had a rule. Their firm would be integrated fully, 50-50. So if a white attorney left, they had to hire a white attorney. If an African-American attorney left, they had to hire an African-American attorney. If a Jewish attorney left, they had to hire. They would not allow the mix to change. And so I really appreciate it. So I happened to apply at the time they needed an African-American. So lucky me. So they hired me. And the one thing, when I got there, I was so scared because it was such a variety. It was like being in a college setting, because you can imagine a firm like that, you're going to have people who are very, outside of the box, the Yale kind of people, because you just got to be open to be in a place like that. And I was scared to death to go to the partners because they didn't have any associates, remember? So I had to go to partners to ask questions. And I was hired to be the first named partner's associate. So I didn't know some of those practical things. And so I was scared to death. I can't tell you how many hours I would spend in that office at night. And I was, my family lives in Georgia, so I was there by myself. Lucky me, since I didn't have anybody to go home to or see. But just to find out, how do I do this? Because I was scared to ask somebody. So that's why I'm taken aback by what you said, because I'm thinking, if I just would have known where to go and what to do. If I would have had a professor who taught me that, I would have called you. But I didn't have that as even something to go back to, let alone know what to do. So they don't know what they need. So that I have to think the proof of that is your reception this semester. So that's what I say to that. Wow. And maybe that's something when the class is entering, the president needs to tell them, we are a school that teaches you the academia of law so that you can go to the most prestigious schools in the country and be a dean of the law school or a professor, or you can go out and put up your shingle tomorrow and know exactly where to go to do what you need to do as an attorney. And when they start getting that sense of we're proud of who we are and we can accommodate you regardless of where you want to go, then they know from day one they're going to get you ready for whichever direction you go. Maybe that needs to start being incorporated in the in what you put out there to define who you are as an institution.
But the disconnect might be with millennials and how they perceive their legal education, or, you know, I don't know if that's part of it.
Please expound on that.
Oh,
Yeah,
I was going to say,
Professor,
Malapati.
okay. Can I call you Professor Pop?
M.
Yeah, okay, Professor M. Okay.
Well, I was going to ask you a question, but I'll just say that, yeah,
Okay.
the millennials is the, you know, the digital age kids. I was going to talk about that a little bit later today, and you know, how they are.
So does that mean they can find everything they need so they don't think you need to?
Exactly. That's part of it. That's part of it. Easy answer.
Oh. But
They
that's
don't want to work. She probably put them to work. I was thinking she probably
Oh, I see.
And so they're,
Because you can cut and paste, and so they figure I can correct.
It's too much. They were probably thinking it was too much what she was doing. But my question is,
Oh, just-in-time learners versus just-in-case learners. That's what we call them.
Yeah.
That, and one of the, they had a, my problem, this is illustrated, because we had a Indian Child Welfare Act problem. And the government shut down last year, right?
Okay.
And so they had to go to the Department of Indian Affairs, which now is called something, the Bureau of BIA. And so they had to find some things on the website. And so they got this information right at the beginning of the semester. And so I said, you need to look at that, and you need to make sure you understand what the deadlines are. And so, of course, the government shut down, and the website was shut down, and it wasn't updated. And so they're like, well, our brief is due tomorrow, and we don't know. And I was like, I said, you can call the BIA and see if there's somebody there. If it's an essential government agency, it might be staff, but they might answer your question. And so it was like completely just so
Oh, and they're
dark.
the digital age, so they should have known that the website could close down.
Oh, no, it's open all 24 hours.
But, and the difference is, because Terry and I talked about this, is the difference is folks from our generation, probably, and a little bit younger, but little millennials, would have gone to that website from the very beginning, printed it out,
Exactly.
saved the PDF, because
We know computers fail.
we know,
And we don't trust them.
and we can't figure them out, right?
Exactly. Because that's the first thing I would have done, print
And
out
so we
like
say
print.
we have multiple copies and we are ready, so we're the just-in-case
Case
learners.
Yeah.
Because we're like, we have multiple drafts
Just
saved.
in case.
Just in case, because you never
never
know.
know.
Whereas a lot of students have more faith in technology than we
Yeah, because
do.
my son will say, well, I don't worry about, because I said, son, you've got to do better at spelling. I don't worry about spelling, Mom. I get everything on spell check on the computer. I said, there is value to learning how to spell. Stop telling me that. I said, there is value. I said, when that line is up under that, do not push that spell check to give you the option. Go look it up in the dictionary. It helps your dictionary skills. You still need to know how to use.
I'm sorry.
He's at Sonia.
That's okay.
Okay, go ahead.
Yeah, but it's a related question.
Okay.
The question is, we are supposed to, as professors, and we're getting more pressure to make practice-ready lawyers.
Okay.
But we only have them for 3 years.
I know. And then they want to reduce that time.
Yeah, we can only do so much, and it's kind of like, and you get them first year,
They can't do anything of that first year.
First semester, you gotta start step one.
Exactly.
Right.
Yeah.
And sometimes we're starting behind step one because we're trying to teach them how to read critically, not just read, but read with depth.
Which is different than what they had to do with us.
Well,
Interesting.
with technology, again, they're clicking on everything, right? And
Shallow.
Wow.
reading. So, we're not even starting at step one. So and then we have 3 years. We can only give them so many practical
Exactly.
that they can't learn.
And that's what I was, when Ms. Paulson, I was,
So there's some
Yeah.
balance there. It's like
Yeah.
we want to give them practical
Exactly.
skills, but we can't give them everything. And I think sometimes the bar puts too much pressure on us.
yeah. And my thought was, when I was thinking through this, my thought is, none of this reality may be none of this could be a class. I so wish the law of life could be some kind of session. But if you could just incorporate a little bit in what you do, like, of course, you incorporate all of that in your class, but like legal research and writing, if you just incorporate that, the blue book and the other thing I talked about the writing, or in trial, maybe it's trial practice professors, you can get them to incorporate maybe a little project where they just work on depositions, like, okay, you're going to do this little project, which is just like a 2-week thing, I don't know, some short. So what you can, my thought is do what you can with what you have, but you're right, you can't do everything. And so you just do what you can. That's all we can do. I mean, especially if they're coming in a step behind. My thought is, I just really think to help the numbers though, somehow the law to life, and I don't know if that's a mandatory, I'm thinking a mandatory Saturday session. Mandatory Saturday session, particularly for first years.
We'd be there alone.
They don't want to come.
Well, the one, it has been taught as a one credit course. I used to teach in a program and we called it Swimming with the Sharks, the Life of a Lawyer. And so we did exactly what you said. We brought in people from, who had used their law degrees in a wide range.
I guess what I'm wondering, don't they realize this is for their benefit? See,
Could it be like a J term kind of thing?
It could exactly be that.
yeah, that's true. Yes.
I was going to ask a question. What do you think about shared mentorship? And what I mean by that is you have academia, right? We're all, I think, mentors to our students. And then you have the professional realm, the law firms and what have you. And then you have the judiciary. But when we're talking about practice-ready lawyers, I do think it is a shared collaboration. And so how do we accomplish that goal? Because as my colleague said, we only have 3 years with them. And in some classes, you only have 14 weeks. So as much as I love the practical application and a lot of things that you said, I have actually incorporated in my class, it's the proficiency that I think is key. And getting to that point, I don't know if it's just one subset of...
You're right, it needs to be everybody. And as you were talking, I thought, is there a list of all the Mercer Law alumni who are located in the Middle Georgia area, and that list and a letter goes out under the signature of the president every year that reminds them of their responsibility to their alumni. And so we expect and we're hopeful that to keep up the standard that Mercer Law graduates have, that you will take on at least one intern during this course of this academic year, every academic year, to come to your firm so they can see and experience the real application of what we try to teach. I mean, you know, kind of goad people into doing the right thing. This is a big thing I have in my courtroom, and you know, I don't know, some people may like it, some people may hate it, but you know, I'm very committed to the fact of staying who I am. And so I say this a lot, and I'm trying to talk to the people who are in the courtroom, but also the people who help me in the courtroom, my bar bill, everybody that's there. I said, we have a responsibility to each other. We owe each other to be there for each other, to support each other. And particularly when we have some connection, and alumni, as I say this, I'm thinking, okay, this goes for you too. But I am doing something for Georgia to help with getting some students in. But they have a responsibility to make a place at the table for people coming after them or in the practice of law, and to help you all help maintain the standard that they want for their school. And I think if it's worded right, you'll be surprised. You might get more people reaching out to get interns. And tell them, you don't have to pay. We want to provide a practical application for our students. If they don't take advantage of it, that's fine. But will you make room at the table? And I can't imagine they will say no. I can't imagine that.
Hi, I'm Karen Sen. Thanks so much for being here today and giving us all of these foods for thought. I'm going to kind of continue what you were talking about with the externship, because I think a way a lot of law schools are building in this practice-ready component is by developing really a robust externship or internship program. And I'm wondering, what can we do to help students maximize that experience? Because I think sometimes they go into that, they're a little intimidated of their supervisor, they're not quite sure, can they ask questions, can they get feedback from drafts, assignments go in, they never come back. What can we tell students to kind of set them up to really get a lot out of that experience?
I think before you speak to students, when you're getting these people to get on board with getting internships, give them expectations. We want them to help us maintain our standards. So will you be open to them coming to you and asking questions, or providing a person who they can go to and ask questions? Will you give them feedback on their writing assignments? If you never use it, will you make sure before they leave that experience that they have an exit interview, an exit consultation, or an exit chat, and you come up with some catchy name, you call it, for them when they leave, before they leave, so they can really get a full sense of it. As I heard you say that, I'm thinking, wow, we should do that. That shouldn't have to happen. And I think with Lane, I've done that, and I'm waiting for her final project for me. But we should do that on our own. but I recognize everybody doesn't feel the same commitment I feel for giving back and the fact that I'm a servant. So you've got to remind them. So before they even go there, make sure that letter that goes out to them or this overture lets them know that you expect them to not just be there, but get something from it, to grow and be better because of the experience. And so, and tell them, please provide the name of this contact person. So when that student goes, says, this is the person who you're going to be your go-to person. If you've got questions, go. They want to answer those questions. And that way you can assure them that this is what this experience is about. They're here to help you learn. Take advantage of it and go to that person. And it is my hope that when the firm or the agency or the judge tells you that, they're going to follow up with it and do it. And, hold us accountable. Do like Ms. Shepherd did, Professor Shepherd. She sent me an email to remind me, you got to be here this time. And I like that. Now see, some people might get offended. I'm regular people. Some people might, but I need that. And in fact, I told one person, you have to send me an email to confirm. My schedule gets so busy, and sometimes I'll say yes and won't tell my what do you call it, judicial assistant, and she gets upset with me, like, Judge, you got to tell me, stop volunteering for stuff, stop. And I have to, every day she hears me say, I am a servant of the people. If people ask and something is not on that calendar, I am there. That's just how I feel. I'm sorry.
Good to know.
If she was here, she'd be like, yeah, so.
Hi Judge, I'm Ann Mullins, and
Nice to meet
sort of a related note to, enhancing sort of the practical experience of our students. One of the things that I'm continually struggling with is I've kind of developed the belief that receiving constructive feedback in a way that's not just professional, because I think most students do receive it in a way that's gracious, but in a way that also is constructive, as opposed to soul crushing, right? And how do you teach students to do that? What are your ideas for sort of how we can set them up? Because I think it's one of the hardest things that we have to do in legal writing.
So you're saying I'm trying to hear what you're saying behind what you're saying. You're saying to be more direct about what they need to do better?
How do we teach them to learn from
constructive criticism?
Yes, exactly.
Well, number one, they don't need to come to law school thinking I'm special because I'm in law school. If we can take some of the ego out of them, take some of the ego like they're better than the professors. Dude, come on. And you know what? That's a life thing. I don't know how we do that, but that's a good question. And how do we? Shoot, that even applies now with practicing attorneys. How do we take? Maybe we set it up as in your role in the academia world. Maybe you set it up by letting them know at the beginning of the class and having them feel this is all about making you the best you can be. And the only way I can do that is to be real with you. And I want you to be real with me. When you walk out of here and people ask you who was your legal research and writing professor, I want that question to be asked because they want to follow up and say, I wish all my associates had that person as your legal writing professor. So my job is to make it where everything that you do, they want you to, every partner wants you to work for them. Because since we've got to feed into the egos to get them to listen, that's feeding into the ego. So we feed into it, and then that's your juxtapose to being real. So when you sit down and have that conversation, remember at the beginning of the semester I told you that I want you to be so good at what you do that they ask, who was your legal research and writing professor? That's why I'm telling you this. That's the only, and they might not like it, but they got to think back. Before I thought she was just picking on me and thinking I'm not good enough. She told me this before she even knew me. And maybe put it in your the syllabus too. You tell them, but you put it in that syllabus as well. And it kind of sets them up for what will come that they don't know. Because I appreciate the teachers, the classes that I did the worst in and had to struggle in the most, those are the professors I end up appreciating the most.
Kind of what we do at Mercer, it's not across the board because it's kind of you sign up for it, but we have an advanced legal writing program where the students earn a certificate, and one of the major goals of the program for the 2 semesters is peer review and teaching them about audience, and not teaching them, but having them work with an audience and get feedback every week from that audience. And so then they're giving feedback to their other 5 colleagues. They're receiving feedback periodically from those 5 colleagues. And everybody, they span the spectrum of students that struggle, students that were on law reviews, students in the middle. And so they learn from each other that everybody thinks differently, everybody offers something, and we kind of give them guidelines in the beginning, sort of a reading with here's how to give constructive feedback. It doesn't help with us in legal writing 1 and 2, but it helps get them ready to give constructive feedback in practice and to get it. And they also sort of learn to work as a team a little bit, which they don't get to do at all in legal writing 1 and 2, and at least not with writing. And so that program helps. And each semester is just a 1 credit, 1 hour a week class. And it's something that you could maybe find a way to work into legal writing 1 and 2 in a less expansive way. But we have found that it really does help them get ready to give feedback and to accept it without it being soul crushing. And so when we had sort of changed the way we were starting off and giving feedback. Before it was just over 2 pages. And then it had to be over a whole brief, 1 person, 1 day, a whole brief. And the very first class, I was really nervous. I'm like, oh, this is going to be soul crushing. An hour of what you could do better. You know? And I don't know if it was the luck of the draw with the student or whatnot, but he was like, no, it was very helpful. It wasn't soul crushing. And so the other students, I think, took their cue from that. Yeah. And I mean, because they got a lot of feedback. It's like, professor feedback 6 times over, right? And then people sitting there in class for an hour saying, well, you did this well, but, and so giving them the guided feedback to show them these are the sorts of things that are helpful, these sorts of things aren't in the beginning, and then kind of as the facilitator of the group reinforcing that as they go in the beginning, pretty soon they get to be really good. And they have very useful insights for the most part. And they all have their own little shtick, right? Like some people it's concision, and other people it's citation, and other people it's grammar, and other people it's substance and analogies. And so, you have the personalities in every group. And so it's nice. It works really well, and it's something to try at least. Great.
One thing I've added is actually professionalism component. So I have a professionalism rubric that tests teamwork, resilience, all those kind of quote-unquote soft skills. And so when we talk about resilience, and there's a learning outcome and performance criteria for it, we talk about this very thing, that the purpose of feedback is for you to get better. And so I'm looking at your ability to take something in that you don't like that may be soul-crushing and to bounce back from it. So I'm looking at your ability to capitalize on that and make it better. And so by setting it up that way, I didn't get any of the pushback from the feedback, because it was all about, okay, I'm gonna get this, and I say I'm probably the kindest person to review you, because a partner might just redline it and give it back to you, and is not going to tell you, or it might yell at you. Like I had a managing partner who yelled all the time. He is a Marine, so he just yells. So he yells at me now, and I'm not there anymore. So and they just really are shocked that someone would yell at them in the workplace. These are like everyone gets a trophy, everyone's awesome. Right? So they're just special and wonderful. And so I think that helped a little bit, and the teamwork aspect and all that, and them understanding that this is something that employers will want to see.
Both Professor MC and Professor Shepard said something that reminded me of what I wanted to say. If you all can incorporate a little bit of civility in whatever you teach, that would go a long way. It cannot be overemphasized. It cannot be overemphasized. I mean, I don't know how, I don't know how we don't just we're not naturally civil to one another in settings, but it is amazing. It is amazing. So just if you can put that plug in, every class you teach, just remind it in different sections when it becomes relevant, would you get, I don't understand how people think you will get your wish when you're less than civil. That amazes me. And that's why I'm almost speechless now, because it's so different than the way I practice. And so when I see it, I'm just amazed that people think that's effective. But
well, and maybe this is what you're referring to, but I was wondering, since you are a relatively new member of the Bibb County Superior Court, if you've had any kind of really surprising moments, or you're kind of on the other side now, has there been something, an experience that's really stuck out in your mind?
I'm very surprised. And you know, it may be coming from the federal to the state side that makes a difference. You know, federal court is very proper. You're doing everything right. You don't question authority. You give citations, but you don't question. They rule in the inside of your head. You're rolling your eyes and saying all manner of evil, but you say, "Thank you, Your Honor," and sit down. And you know, state system, superior, it's just different. You know, people feel more lax and at home, and so they just do whatever. I'm a big proponent in being prepared. You know that, and I say this before I begin any court proceeding. I respect what you do, and as a result of that, every piece of paper that's in this file I have read. I owe you that as counsel on this case, and so know that I am prepared. So as you present your arguments, understand I've read what you've written. So this may not be a presentation, it may be more of an appellate style, because we can discuss this because I know the facts. And so I say that every time because it became obvious to me that people were not, number one, they were not used to that. They were sometimes not prepared for the exchange that I wanted to have. And so I am, and that in federal court, maybe it's just me and who I am as a person, but I knew my case better than anybody who walked in that courtroom. And so I'm just amazed at everybody that doesn't always do that. And so, you know, remind your students like you do even in class, you got to be prepared. You've got to know your case better than anybody in there, because chances are if you do, you might be the prevailing party. Because you're going to bring the right kind of case, you're going to have the right kind of law to get the results you want, or at least you know going into it. Dude, we're going to probably lose this. I'm going to fight the good fight. You know, I mean, preparation is key. That's what something I noticed.
We got you on video, so we can just play that to the students.
Oh my God, I forgot this is being videoed.
My judicial field placement students, and it meant a lot. They all talked about it for the rest of the semester. They talked about if they saw somebody in court where it was at play, and how they doubted what she said. They were like, whatever. And then they saw it, and they're like, wow,
that's
right.
That's good to know. So,
it was in federal court, too.
It was in federal court? Wow. Something good or something bad?
Something good.
Okay. Yeah, so I just, and I'm learning, I'm just like new professors or law students, I'm learning as I go. I'm having to make adjustments because I hear I'm a little stringent. I'm very big on time, and so my judicial assistant has to tell me all the time, it's okay if we're 5 minutes late, Judge, and see, I'm not from that school of thought. I mean, I value everybody's time, whether you're the person who doesn't know where you might live tomorrow, or whether you're from the finest firm in Macon. I value your time, and so I'm having to learn to adjust, but I have to adjust to some extent, but I start on time. But so those kind of things, the little niceties. That's what floors me sometimes. Not seeing just the little niceties done toward each other and people and pleadings and human nature. I say all the time on the bench, and that's why I know I'm so different. But I can't help it. I'm just who I am. You can't make this stuff up. I mean, it's just, and you all probably say that as professors. Some of the things you see and experience, you think, I couldn't have made this up if I tried. So every day is like, what adventure will I be on today? And so I think the biggest thing we can teach professionals is our reputation and our character is all we have. At the end of the day, who I am will be determined by what I do and what I stand for. And I wonder, do we get that across really well in law school? I wonder, do we miss the opportunity to remind people of just who they should be as people? You know, getting a law degree, becoming renowned at what we do, that's great. But at the end of the day, we're still people who should care about other people, regardless of what we do. And so if you care about other people, civility doesn't need to really be discussed. If you care about other people, being prepared doesn't need to be discussed because you respect that person you're coming in front of. If you care about other people, then time is not something that becomes an issue. And I just wonder if the bottom line for, you know, whether it's law or anything in general, is our lack of concern for anything outside of what's around us. And I would say this whether I'm talking to you all, or educators, or probably in every setting I go into that I talk, this is my mantra, because it seems like as a society we've forgotten that in almost every area. And it's about me, myself, and I, and how I can make my world better, and less about others. But I know that's not true because we are one of the most giving societies in the world when it comes to giving voluntary donations and volunteering time. So we have to ask ourselves, where does the disconnect come in the day-to-day life? I don't know. But I just, because, you know, and I tell people all the time when people make lawyer jokes, we're better than that. Now, I know you may have had some experiences, but that's not who we are as an entity. And so I think, what can we do to change those jokes? And you know, when I have people appear before me and said, thanks, Judge, this is the first time I feel like somebody actually heard me or listened to me. And everybody, I will tell you, when I was a federal prosecutor, the people who I sent to jail would call me. Miss Colvin, I just called you to talk to you, tell you what's going on. I get some calls from jail, tell you what, you know, they get their parents to pay for it, tell you what's going on. I just want to talk to you a little bit. And you know why they want to talk to me? They just wanted somebody to hear them, to be inspiring. And for the moment in time you're with them, just care. And so it'd be nothing for me to stand up there in sentencing and tell a person, this does not define you. Whatever your sentence may end up being, this does not determine where you ultimately will be. You determine that. You take this time, use it to get better, to do better, and come at it. So they know she doesn't play, but she still, you know, can empathize. I just think we ought to do a better job of that. And maybe you all can help us espouse that in little ways in what you do. You know, in little ways. Just, you know, drop the ego. You know, drop the ego at the door. You know, and I don't know why law students come in with such egos. I came in law school, I was scared to death. But, you know.
I think some people are scared and they're compensating with extension of their ego, right? And I'd also say that I think a lot of people come to law school thinking it's an adversarial system. We hear that, and we forget that it's also very collaborative.
Exactly.
In working with your colleagues. You might not be working with opposing counsel, but you're actually doing a lot of collaborative work, and that's not emphasized, especially in a graded environment where students are graded on a curve and feel that they're competing with each other and against each other for those.
And I will tell you all, I think Macon has one of the best bars as it relates to people genuinely liking each other and getting along. It is very warm, it's very welcoming, and very different than what I hear that exists in metropolitan areas like Atlanta, for instance. And so this is a warm and wonderful place to be a lawyer. Having been here for so long, I don't know if I'd ever want to go back to a big city and practice law, or even, I can't imagine being a judge in a bigger city, what that must be like. And so it's a wonderful place. And most days when I go on the bench, I'm happy to be there, and I feel so privileged to be in front of attorneys who are well prepared and presenting arguments and give me things to think about. It's so refreshing. I feel like a professor, almost like I get to think like, wow, okay, what about that concept? And so I want to leave with that impression. This bar is phenomenal. And so the little things I talk about are small things that sometimes come up. But preparation is key, and I know you all are preparing students for that. And so that's just my little tidbit of things that I thought I could add to the discussion. pleasure. I really admire you all. Thank you for doing what you do. One reason why I am doing what I am doing is because of the professors I had who made me think out the box, who challenged me. And so I have a high regard for educators. I just do. I think you all should make, I think all educators should make more than a lot of professionals, but I know I differ on that count. I'm one of those people who feel like educators don't make enough, because if you pay them what they're worth, particularly as it relates to the elementary, high school, and all those, if you pay them what they're worth, then you can get what you demand for your students. And because we don't, that's kind of why we're where we are.
Where's the dean?
But that's just, I have always had that philosophy. I just think, and then we wonder at the product. Well, what you put in it is what you get out of it. So, but anyway, thank you all so much.